You're going to have to make better decisions from here on out. Everything that you do,
Yes,
you need to
ma'am.
ask yourself, could it result in you going to prison for 20 years?
This courtroom double feature isn't your average sentencing day. It's a clash of second chances, strict probation rules, and the haunting reality of past mistakes. First up, Thierry Ranford, a man standing before the court with a plea for mercy and a promise to change, but carrying the weight of a drug problem and a history the judge can't ignore. The stakes? Up to 20 years in prison. Will the court take a gamble on his probation application, or is he headed straight to a cell? Then, in a twist, we move to Angel Montoya, whose probation record is anything but clean. Multiple violations, prison time, and a battle to prove she's turned her life around. Her lawyer insists she's a changed woman, but will the judge buy it? This isn't just about sentencing. It's about redemption, relapse, and whether the court believes that people can truly change. Stick around, because the judge's rulings today will shock you.
All right, court is calling 2023 CR 6906, State of Texas versus Tyree Joseph Ranford. Could our parties announce for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Monica Guerrero for Mr. Ranford.
And are you Tyree Ranford?
I am.
All right, you entered a plea on September 28th of no contest and also a plea of true to the enhancement. And we're now here for sentencing. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison, and the state is silent on your application.
Here's where the legal drama really kicks in. The defense has just laid it all out. Thierry knows this judge's reputation, no-nonsense probation, zero tolerance for slip-ups. That's not an exaggeration. In this court, probation isn't a soft landing. It's constant testing, constant monitoring, and if you fail, you're going straight to prison. The letter Thierry wrote to the judge? It's a calculated move, humanizing himself, showing remorse, and promising to get clean. But let's be real, judges have seen hundreds of these letters. The question is, will this one actually make a difference?
Have both parties had a chance to review the PSI report?
We have, Judge.
Any objections?
We don't have any objection.
All right, anything you wish to say on behalf of your client?
So I explained to Mr. Ranford what the court's policy is, and that many people ask you, why would you ever want to be on probation in the 187th? Because when you mess up, you're going to prison, and that you make the prison probation conditions very, very difficult. I've explained all that to him, and I told him that you don't play around, that he will be drug tested, that he will be checked throughout this thing if you give him the privilege of having probation. He said he understood that and he wanted to still apply. He also wrote a letter to you that he would like for you to consider to read. He thinks he would be a good candidate for probation because he's already getting too old to be messing around anymore, and he doesn't want to end his life having chronic back pain and trying to treat it himself. I don't know if you wanted him to read it to you or if you want me to tender it to the court.
If there's no objection.
No objection, Your Honor.
All right, and if I could see the letter. All right, anything else you wish to say, Mr. Ranford?
Well, no, ma'am.
This is a critical moment, the fork in the road. The judge is blunt. You can get help for your drug problem, or I can send you away for 3 years right now. That's not a scare tactic, it's a reality check. Notice how the judge frames it as a choice. But legally, the help option comes with serious strings attached. 8 years of deferred adjudication means that if Thierry slips up even once, the full sentencing range, up to 20 years, comes back into play. This is the justice system's version of a loaded gun on the table.
All right, so sometimes I can give people choices, sometimes I cannot give them choices. It's obvious to the court that you have a drug issue, right? So if you want help for your drug issue, the court will give you help for your drug issue. Or if you would like, what I can do is I will sentence you to 3 years in the prison. Which would you prefer? Okay. There's an application for deferred adjudication. So with your application for deferred adjudication, if you are unsuccessful, then the full range of punishment will be open to the court, which is up to 20 years in the prison. You understand?
Yes, ma'am.
Listen carefully here. These aren't just conditions, they're landmines. Regular reporting, no unsupervised contact with minors, 200 hours of community service, proof of employment within 30 days, sobriety meetings every single day for 3 months straight. And that's before even mentioning the random home visits. This isn't just about staying out of trouble, it's about living under a microscope. If Thierry thinks probation means freedom, he's in for a rude awakening.
All right, I'm going to sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be the UA hotline. This is to run concurrent with County Court Cause number 698064. Taking consideration 707108. NIMAG numbers 709-145, 722-670, grand jury number 804-578, proof of employment within 30 days of release, no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors, 200 hours of community service restitution. Do you have any children?
No, no.
Will you be living with someone if you're released?
Yes, Your Honor.
And who would you be living with?
My father.
Okay, just 1 second. Let me see what the TAP evaluation tells us. All right. There's going to be a transfer to SATA. So you're going to stay in custody until you transfer it to SATA. And we can also do a referral to felony drug court. Felony drug court has a wait list, so they're probably not going to be able to accept you. So you'll be going to SATA.
Right.
And upon release, I'm going to want 90 sober meetings in 90 days. Field visits, 1 time per month for 4 months. And then within probation's discretion thereafter. Probation, is there anything else he needs? All right, is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
This right here is the judge's signature move, the parting shot. If it could send you to prison for 20 years, don't do it. If the answer is maybe, don't do it. That's not just legal advice, that's life advice. The judge is laying out the reality. One bad decision, one bad day, and all of this leniency disappears. And trust me, when a judge repeats themselves in open court like this, they're not talking to fill time. They're making sure the defendant can never claim, "I didn't know."
All right, good luck to you. We can go off the record. You're going to have to make better decisions from here on out. Everything that you do,
Yes,
you need to
ma'am.
ask yourself, could it result in you going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, Your Honor.
All right, and in this court, to be successful, your counsel probably told you communication is key. If you have an issue, let probation know. If you feel like they're not addressing it, you can always come to court, okay?
Sure.
All right, good luck to you.
Thank you.
All right, court is calling 2019 CR 10494W, State of Texas versus Angel Montoya. Can I have parties announced for the record for the state
Shotgun for the state.
defense?
Ed Piper from Miss Montoya.
Are you Angel Montoya? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Angel Montoya who's placed on deferred adjudication in 2019 CR 10494W for the offense of possession of marijuana 4 ounces to 5 pounds on September 24th, 2019 for a period of 2 years?
Yes, ma'am.
State.
And now, case 2. Angel Montoya's story is the perfect contrast to Thierry's. She's not asking for probation. She's already had it and lost it. Failing to complete community service is the official violation here, but that's just the surface. Behind that is a history of new charges, time served in prison, and a track record that screams instability. Her lawyer's job now? Convince the judge that despite all this, she's finally on the right path. It's a tough sell, and the court isn't easily impressed.
On or about the 27th day of January 2021, in Bear County, Texas, the defendant, Angel Montoya, did then and there fail to complete 50 hours of community service restitution in violation of condition number 14.
How do you plead to that? True or not true? Did you understand? I'm sorry. Are you waiving the other allegations?
Your Honor, the state waives and abandons the other allegations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition 14, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 14? Court will find violation of condition number 14 true. Is there a proposed agreement?
Yes, there is, Judge. I've spoken with probation and I've spoken with counsel for the state. And we agree as well with the recommendation that her probation be terminated unsatisfactorily.
All right, what has she done?
Judge, what she has done is that while she was on probation, she had another incident out of Kendall County shortly after that. She spent 18 months in prison in Plains State in Dayton, Texas. She was recently released in July. And since that time, and having spent that time in prison, she's changed her whole way of thinking and doing. When she was released, she was put on UAs for every week, no problems. Now she's on random, no problems. I asked her if I offered her up today for you to prove to yourself that she is clean and sober. She's perfectly willing right now to step up and do a drug test.
All right.
This is where we see the real gamble of the justice system. Montoya's lawyer paints a picture of transformation, clean drug tests, steady compliance, a willingness to prove herself on the spot. But the court's decision to terminate her probation unsatisfactorily is telling. It's not a gold star, it's a polite way of saying, we're done with you, but we're not convinced you've earned redemption. It's freedom, yes, but without the stamp of approval that a successful completion would carry.
She's just done with that life.
All right, based upon the probation's recommendation and agreement, the court will find violation of condition number 14 true. The court will terminate her unsatisfactorily. What is happening with 2022 CR 0054?
Judge, 2 days ago, Mr. Dunn and I spoke. I brought to him new evidence, not new evidence that we had found, but we were waiting for getting the evidence because the person that we were getting evidence from was incarcerated himself. But I've had 2 conversations with him since then, and the information he is giving me is material and substantial to this allegation, and I am giving that information to Mr. Dunn to interview my witness.
All right. So with regards to the cause number 2022 CR 0054, if we can get a reset on that for November 30th.
2 cases, 2 defendants, 2 vastly different outcomes, yet both carry the same message. The courtroom is where reputations, second chances, and futures are decided in minutes. For Thierry, the road ahead is long, steep, and filled with conditions that will test him daily. For Angel, the chapter closes with freedom, but also with a record that tells its own story. In both cases, the judge's role was clear: balance the law, the facts, and the hope for change. And that's why these moments matter. If you found these cases as fascinating and as telling as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.